Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Maritime Law, Introduction to Shipping Law, Singapore Law Watch. C. Bill of lading as a document of title. 1. The bill of lading is document of title, which enables its owner to raise credit for an international sale if it is an order bill. A bill of lading is often described as a document of title which enables the owner of the goods in respect of which it was issued to raise credit for an international sale. However, it is pertinent to note that the bill of lading may be regarded as a document of title only if it is an order bill under which the carrier agrees to deliver the goods at the port of discharge to a named person or to his order as assigned. An order bill of lading may be transferred by blank or special endorsement for the bill of lading. A bearer bill of lading, which is rare, may be transferred by physical delivery of the bill. A bill of lading validly endorsed in blank function like a bearer bill of lading, in that it may be transferred by physical delivery. A straight consigned bill of lading, not a document of title in the sense of being negotiable, but it must nevertheless be presented before the carrier can deliver the goods shipped thereunder. 2. The bill of lading entitles its holder to the delivery of goods against presentations of the bill. 25.4.10 As a document of title, the bill of lading entitles its holder to deliver the goods against presentations of such bill. Accordingly, a delivery to the holder of the bill of lading, even where he has not paid for the goods, discharge the ship owner from any liability, provided that such delivery was made in good faith and without notice of the holder defect in the title of competing claims for the goods. A ship owner is liable for the breach of contract of carriage and or convention on the cargo if the goods were delivered to a person without production of the bill of lading. A carrier who delivers cargo without surrender of the bill of lading or against the productions of a forged bill of lading does so at his peril. The anarchist Kai, a seller who holds onto the bill of lading although having received partial payment from his buyer, is not stopped from suing the carrier who delivers the cargo without productions of the bill lading. 3. Switching of bills of lading is a dangerous practice for the ship owner, but it is afterward if means to conceal the identity of the shipper or to split bulk cargo. Switching of bills of lading is relatively common practice, but is one fraught with danger to the ship owner, especially if the switching is imperfectly carried out and two sets of bills of lading are left in circulation. There is, however, nothing afterward if the switch is solely to conceal the identity of the original shipper from the receiver of the goods or to split a bulk cargo into smaller quantities. D. Rights of suit under bills of lading. 1. The Bills of Lading Act transfer all right or suit for a contract of carriage, not including charter parties, to any person who lawfully becomes the holder of a bill lading. 25.4.12 Rights of suit under a bill of lading were previously governed by the 1855 Bills of Lading Act and depended on the passing of property in the goods shipper under the bill of lading by reason of the endorsement of consignment of the bill of lading. The 1855 Bills of Lading Act has been abolished and replaced in Singapore by the current Bills of Lading Act, which is in pari material with the UK carriage of goods by sea. 25.4.13 The BLA removes the link between contractual right and the passing of property and allows the assertion of right of suit against the carrier irrespective of the passing of property in the goods ship. As such, a person who becomes a lawful holder of the bill of lading as defined by the BLA has, by virtue of becoming the holder of the bill, transferred to and vested in him all right of suit, and if he had been a party of the bill of lading. For the purpose of the Act, the holder of the bill of lading can be in either physical or constructive possession. 2. A person who has the right of suit may exercise the right for another person who has an interest in relation to the goods to which bill of lading relates and sustain loss in consequence of a breach of contract. 25.4.14 Where a person with any interest of right in relation to goods to which a bill of lading relates sustains loss or damage in consequence of a breach of the contract of carriage, but rights of suit in respect to the breach vested in another person. The other person is entitled to vested in another person. That other person is entitled to exercise those rights for the benefit of the person who sustained the loss or damage to the same extent as they could have been exercised if they had been vested in the person for whose benefit they are exercised. 3. A bill of lading is not transferable where the goods are specified to be delivered to a named person. 25.4.15 A bill of lading is not transferable where it requires the goods specified in it to be delivered to a named person, omitting any language of transferability. Such a bill is described as a straight consignment bill of lading. For the purposes of the BLA, a straight consigned bill is treated as a way bill. Where a bill of lading is endorsed by a special endorsement, the bill of lading ceases to be transferable until it is endorsed by the name endorsee. 25.4.16 The endorsement of a bill of lading may be by special endorsement. In example, it may name the transferee to whom delivery is to be made. If no transferee is named, the endorsed is called an endorsement in blank, and the goods specified in the bill of lading are deliverable to the bearer without endorsement. So the time is up, and the article will be continued to read in the next video. So bye bye, and don't forget to watch the next video. Bye.